Good morning, good afternoon, and good evening, depending on whichever part of the world you're in. I thank you all for joining us today for our first SIAC India webinar in the ongoing International Arbitration Series. We'll try and take as many questions as time permits. Please use the Q&A function at the bottom of your screen to post a question. I'm absolutely delighted to introduce you today's guest, one of my favorite lawyers, someone from whom I have learned a lot from and had the pleasure to work with. We have with us Mr. Harish Salve, possibly the only Indian citizen who's a Queen's Counsel practicing both in England and India. He's also senior advocate of the Supreme Court of India, barrister at Blackstone Chambers, former Solicitor General of India, recipient of one of India's highest accolades, the Padma Bhushan, and last but not the least, a member of our Court of Arbitration. Besides being known for his sharp intellect, exceptional oratory skills, and impeccable court craft, very few would know that he's also a piano player and jazz aficionado. Mr. Salve, welcome to the webinar, and thank you again for your time. I'll start with our first question. So everyone has been talking about the challenges that they are facing and how there is so much difficulty with this current pandemic. But it's, I think, at the same time, hard to imagine that humanity has ever been on a steeper learning curve. What has been your greatest learning from this pandemic, and where do you think we will find ourselves at the end of it?
So yes, it took a pandemic to teach this old monkey some new tricks. I've had, in fact, ironically, in February, when we were in the beginning of this problem, and I had a big arbitration starting in March, for which we had been preparing for 6 months. And one of the suggestions came up about having a virtual hearing. I said, no question, I'm not agreeable. And for the simple reason, I felt, how can you cross-examine a witness if he's not in the same room? And unless you can connect with his energy and sort of zoom in on him personally. If the same situation arose today, I don't think I would repeat that. So yes, we have learned, because we were driven to learn, we have learned how to work virtually. Yesterday, I had a 2-hour hearing in the Supreme Court of India for a very controversial case involving a journalist. And I think it went very well. Apart from a little fine tuning of how to use the system, because at times when the judges were asking me questions, I had the other lawyer's face on my screen. So I think these are minor hiccups which we will learn to resolve as we go along. I think the system is working quite well. And for smaller hearings, I think we will be able to use this and thereby save a lot of costs and inconvenience to clients, which is one of the USPs of arbitration. I, in fact, was to do a hearing in March. Then the Indian court intervened and it got pushed off. It's a ICC Singapore monitored hearing before an emergency arbitrator, and we were all ready to go. And now that case is in the High Court, where your erstwhile boss is instructing me. And we have a final hearing tomorrow of an appeal dismissing the other side's suit on the system. And we'll be arguing using, High Court uses WebEx. Supreme Court uses something called video. And they both work quite well. So yes, we've been pushed into a situation where we've had no choices. But I think at the end of the day, this solution should be kept and used more frequently. There are of course huge advantages if you're doing a big case. There are huge advantages to all being in the same room and in the same city, same country, same venue, same room. But for smaller hearings, for day hearings, etc., I think this is a very good platform. And we should use this more and more.
Yeah. I mean, that's like you said, it's really being compelled to now use it, and all of this reluctance is just being, thinking that we will not be able to work this out. Yeah. Just moving on to, in fact, because of the lockdown, I managed to read a few books, and one of them was Mr. Nani Palkhiwala's biography, and I couldn't help but remember the times that I've heard you mention him. If you could share, the role that he's played in your life, and if you can recall any particular episode that you treasure the most.
So, oh my God, Mr. Palkhiwala is, he was a lawyer who, apart from his complete understanding of the law and understanding of the philosophy of the law, his forensic skills were incredible. The way to present a case, what to say, how to say, when to say. The three key elements of advocacy, and when not to say, and what not to say. And that is what we learned from him, apart from, first of all, his attention to detail. If you started by showing him a judgment of a court, he would say, no, not now. Let's first look at the facts. First look at the section. And my first experience with him was in 1978, a little while ago. And I went for a conference with him on a tax matter. And we had a problem with construing one particular section. Mr. Dadachandji sent me, it was an income tax problem. It was a new provision inserted. And he said, let's read the section. I said, okay. So we read, by the time he finished reading the section, the way he read it, the places at which he paused at reading the section, he said, now what's the problem? I said, there's no problem. He followed. He had already answered the point. We were in, should it be read like this or should it be read like that? He just said, let's read the section. And the way he read it, he said, yeah, of course. He said, anything else? I said, no, sir, thank you. And I remember one of the important cases we argued, which ultimately led to the Renu Sagar arbitration, which came to Supreme Court 3 times over. The genesis of all that was that the Hindalco, which was Renu Sagar, which was the partner of GE. GE had exemption had obtained a specific exemption, as those days it was required to be obtained, for payment of tax on the interest and royalty. And the parties had negotiated and they had reduced the rate of interest. And the tax authorities said, you have, without our permission, reduced the rate of interest. And we will therefore cancel the order. Of course, a writ petition was filed. It came up. Soli was appearing. So he was leading me. We appeared before single judge, cited all the administrative law cases, non-application of mind, natural justice, etc. We were winning the case hands down. Mr. Palkhiwala was appearing for GE. He got up and he said, let's read the section. He read the section and everybody had seen. The section said interest at a rate not exceeding that approved by the government. He said, we are paying less. So it's interest at the rate not exceeding the government. What am I doing wrong? And he sat down. We won the case. So this was Palkhiwala for you. He suddenly came and said, therefore the government approves the cap. It doesn't approve the rate of interest. That was his point. And we said, but of course, it's so simple. Nobody thought of it. The tax authorities didn't think of it. 2 lawyers who appeared before the tax authority didn't think of it. Mr. Sorabji didn't think of it when he was arguing it in the High Court. It required a Palkhiwala to just get up and say it, and the case got over. So, this was his amazing way of addressing a case. Devil lies in the detail, as they say. And this is one thing I've learned from him. The second thing I have learned from him is, when you write or when you argue or when you present an argument, when you write a piece, it should be written so perfectly that nobody should be able to reduce even a word from what you've written. And that's how it is the most effective, the most convincing. And I remember one of the biggest points of constitutional law which we argued. Parliament had, after the, the Keshwanand Bharati judgment, which said you cannot amend the basic structure of the Constitution. Parliament amended its amending power and said we can amend the basic structure of the Constitution. Everybody knew that was wrong. It was challenged in Supreme Court. And when it came to this point, I remember a 5-judge bench, Senior Justice Chandrachud presiding. He said, Mr. Palkewala, you have one more point. The second point, how long will this challenge take? He said, 5 minutes. He said, really? He said, yeah, 5 minutes. He said, how? He said, my point is very simple. The donee of a limited power cannot, in exercise of his power, enlarge his own power. So that's my point. I have nothing more to say. And that's formulated by Supreme Court, and they struck down a constitutional amendment on that one sentence. So this was what I learned from him. And on a personal level, what I learned from him was that a lawyer is always a student of law, always willing to learn, always ready to learn, and how one should behave with younger members of the bar. When I was a youngster and he was this, how much affection he got. And the innate humility of the man. First time when I appeared with him, and my father was a great fan of his, being a tax chartered accountant. And when he met my father, I can never forget what he said. He said, NKP, it is such a pleasure working with your son. He didn't say what a pleasure it is to have your son working with me. It struck me that this is what a human being should be like. So I can go on about Mr. Palkewala, but this is what I learned from him, the fine art of advocacy. How to present your point, what to say and what not to say.
Yeah. I think I can safely say I see a lot of reflection of him in you. And of course, I remember the cases, that I did with you. Yeah. Just going back to 2013, when you moved to England and joined the English bar, you already were a leading player in some of the largest India-related disputes. But how has the transition been from Indian courts to English courts, and what sort of spur you on to make that move?
So, the change had started coming, and if I may be totally candid, when we started work in 1980s, we had gurus. We were working with Fali, Soli, and they were very hardworking lawyers. They would never enter a court unless they would be fully prepared with the case and fully researched, etc. Over a period of time, post-90s, I think in India, the workload increased so enormously that senior counsel's work started becoming shoddy. And as you know, I had sort of reached a point where I was a little at odds with my colleagues. They used to all wonder, why do I need 10 days to prepare a case? Why do I need to be in London for 3 weeks, holding conferences to argue Vodafone? Most of them would have done it with a 2-hour meeting and gone and felt their way through the case the way they do. So this change had started. I had started feeling this. And, Mukul used to laugh at me every morning saying, 9 weeks, you're arguing Vodafone for 9 weeks, 5 weeks, 6 weeks, 7. We argued it for 9 weeks, if you remember, in the Supreme Court. And we did nothing else in those 9 weeks, which for them was a big surprise, that Mondays and Fridays, you're not accepting briefs because you're doing SDR, because that's the day we sit and prepare for the next 3 days. So this change had started coming, this high volume, high intensity, low preparation retailing of advocacy was not really my style. It was very, very financially lucrative. But it is not cerebrally satisfying. And then we would do arbitrations. I'd come and work in London. And that is what I said, this is how one should be working. So the transition for me, actually, I carried my work style and improved it and added a lot more quality once I moved to London. So for me, the transition hasn't been that difficult. Yes, I miss court, but then I've had enough of court, the day in, day out in court. And I'm now getting into court practice here, which I will, again, never do the 5-day a week stunt here because nobody does that here. But I'm quite enjoying this transition. I think it just gives me more time to do more serious, better prepared work and deliver much higher quality to the client, much higher quality service rather than the kind of retail stuff which we had started doing at one stage in Delhi.
I'm sure the Indian courts haven't had enough of you for sure. And I'm sure a lot of us miss you around being in India.
You know, even the judges are under so much pressure of work and this, they don't have the patience for long arguments. They don't have the kind of work they do is also more a churn kind of a work. I mean, some of them are very serious judges. Some of them are very fond of getting into the academics of a problem before them and also that is there. But, and yes, I haven't given up on Indian work completely. Still keep in touch.
So in fact, you've been at the forefront of some of the leading cases, in the cases before the International Court of Justice. There's been the Vodafone case, and of course, constitutional matters, and a lot of BIT cases and commercial arbitrations. What do you consider as your greatest achievement and your greatest strength?
In greatest, you mean the most important case I've argued?
Yeah. Case that you felt was very important to you and you enjoyed working it at the most.
So, you know, some of those cases which I have thoroughly enjoyed working and come out happy at the end of the day. One was the 11 judges, the minorities case, despite all the political pulls and pressures. The pure constitutional law analysis, the Gujarat reference, no authority, no precedent, important questions about discretionary powers of governors, presidents, some of the commercial law cases which you've argued like Balco, seat of arbitration. I enjoyed arguing that case, completely up my alley. Tax-wise, I think the most exciting case I've ever argued is obviously Vodafone. And the 9 weeks which you were party to also. They were thoroughly enjoyable. It sort of had to bring out all the reserve, all the years of work which we had put in because the case went all over the place and there were so many overlapping issues involved. So some of these cases and some of the constitutional cases I have done, some of the tax cases which I have done, Vodafone was of course one of them. There are other big tax cases I have done, which I thoroughly enjoyed. So these are really my areas of work, which I can say I have had great fun doing. I've enjoyed my arbitrations. And I enjoy my arbitrations thoroughly, where you prepare in detail, where you cross-examine witnesses. So we've gone back. As youngsters, we used to do small trials. Now we've gone back to doing trial work. So I've enjoyed that thoroughly, doing trial work in arbitrations, cross-examining witnesses, which is something which I love. And I must say the BITs, which I have argued, four or five of them now, were completely a new experience, and they were delightful. And you have different tribunals. I argued Vodafone, and I argued exactly the same point for Vedanta. And there were two completely different tribunals. Their approach was different. The personnel was different. The way they heard the case was different. And it's been a fascinating experience. I mean, in one, I was given 2 days to do my closing, or 1.5 days to finish my closing. In the other, I was given 45 minutes or 90 minutes to do my closing. We managed to do both.
Anything from the litigation that you feel, any feature that can be brought to international arbitration and that will really change the efficiency of international arbitration?
Not really. I think international arbitration over a period of time, especially the way it has evolved, is doing wonderfully well. In fact, and this is something which I always tell Indian judges who join arbitral panels, please don't give up your habit of reading. As Indian Supreme Court judges, they do a lot of reading. Unfortunately, when my experience is the 2 or 3 times when they come for arbitrations, their files are unread. And I told them, you can't come into an arbitration and open your file. That's not how arbitrators work. You have to be fully up to speed. You can't start by saying, yes, I have read the statement of claim, I have some rough idea. Then, oh, sorry, it doesn't work that way. And don't only read the skeletons. So I think those reading habits should come across. In fact, it will be happy in a country like India if we cross-fertilize court proceedings. Like you'd be happy to know when a PL was filed in Supreme Court, and the Chief Justice, Gogoi, that time, he said, let's recast the commercial courts. And the Chief Justice, Geeta Mittal, that time, was very happy. She called the original side bar. Originally, there was huge howls over writing up the rules for the commercial court. And what I did is I took our SIAC rules. I took the English code, the rules of court, the civil procedure rules. And I wrote up the Delhi High Court commercial court rules. And finally, we managed to persuade the court. And if you notice, I think Delhi High Court is the only court which in its rules has the red fund schedule.
Yeah.
So it's in fact, it's the arbitration world which is cross-fertilizing court work in India, where there is so much pressure of work that the judges need to speed up. And I think a bit of that will also happen in the UK, where there'll be cross-fertilization, as it is with the post-Wolf reforms. Now, for example, on so many procedural matters, the UK courts commercial court is so sensible. In India, you waste time arguing an amendment application for 3 hours. Here, you can amend in the middle of a trial and the judge will, as long as the other side is not being taken by surprise, there are no technicalities here. So it's become a lot more user-friendly. And I think the big USP of arbitrations is it has to be kept user-friendly. Not too much stress on formality, not too much stress on following civil rules. As long as there's substantial compliance with natural justice, get on with it and decide it. And that approach, let's get on with it, let's crack on, is what good arbitrators say. And that approach has to be maintained in arbitrations and in court proceedings also.
I think going back to commercial arbitrations and bilateral investment treaty arbitrations, which you've done empty number of both, have you felt any difference in terms of practice and procedure, or any skill that you felt that needed to be especially?
Yes. So I have done 4 or 5 BITs, and they've been of very different types. And for example, one of the BITs which we did was against the government of India in a very politically sensitive case where the ISRO had signed for a lease of a satellite, which they cancelled because somebody suddenly realized that the spectrum being made available, the American technology had evolved so much that spectrum could be refarmed and reused. And for a fraction of the 3G price, that spectrum would be available to the person who leased. And his main revenues would have come from refarming the spectrum and using it for broadband internet. So that became a political upheaval at that time. As it is, there was trouble about the 2G. So somebody said this is a bigger scam than 2G, and the government in a knee-jerk cancelled it. Now that came before an arbitral tribunal, which had an Indian judge, Anil Dev Singh, which had a chairperson who was one of the most remarkable human beings I've seen, Mr. Lalonde. And it had a Canadian QC, who my clients had appointed. Mr. Lalonde is, I think, 80. And we had 14 witnesses, combining both sides. And we finished the arbitration in 6 working days. we would start at 9 o'clock. 3 days we ran till 7. The fourth day we ran till 7:30. And he used to be there on top of the hearing all the time, never slacking off. Never did we feel that his attention is wearing off because he's exhausted, as he must have been at times. So but presenting a case like that, where there are serious allegations of malafide against a government at the highest level, including we were referring to cabinet minutes and Prime Minister Manmohan Singh saying something and the ISRO chief saying something. And an international tribunal tries to deal with it very delicately. See, in an Indian court, we could have said a lot of things, but the international tribunal was feeling a little embarrassed. So you have to be very guarded in the language we used. And I remember I was co-counsel with an American lawyer, very, very fine American lawyer, partner of Skadden. At times he used a little harsh language. And I could see Lalande wincing a bit. And then we had a little chat. So when in my submissions, I made sure I made it palatable. I made it consistent with international norms of civil behavior and civil conversation about a sovereign government. So that was the first time I felt that there is, and rightly, a sensitivity in international arbitrators that they are dealing with the sovereign functions of government. So they are really like an international court, as it were. Yeah. And you have a sovereign republic appearing before you. And therefore, how do you address sometimes, and many times the allegations, as you've seen in the awards, are very serious, saying so-and-so politician hated me and he got this cancelled or he got this done. Allegations of malafide conduct are very common in internet, BITs. And you have to place them very gently so that the arbitrators, and at least in the course of hearing, they don't want the temperature to go up. Because sometimes these can become very controversial allegations. And how you examine witnesses, the arbitrator, you have senior government officials whom you're cross-examining. The arbitrators don't want them to feel that they've been humiliated. So you have to go a little easy on the government witnesses. And all this is a completely new experience, because in a commercial arbitration, you don't care. But in a BIT arbitration, I could see, I was cross-examining 2 witnesses from the telecom department who had very high sounding offices, but I knew that they were not even joint, they were director level, they were not even joint secretary. Now, and they'd been, the American lawyer appearing for the government of India said, oh, he is so-and-so, and he had a very high sounding title. Now, how do I tell the tribunal that this fellow is a very small fry in the ministry? So very gently, I had to sort of ask him what his functions was, how many people were above him, how many people. Couldn't straight tell him, listen, aren't you a sidekick of the secretary? So this is the delicacy I have seen, which involves a different kind of lawyering skill in BITs. Like in the ICJ, you have to be very careful about what you say in the ICJ about the other country.
You've been at both sides, you've acted for the government and you've acted against the government in a number of cases. How do you balance the two?
Well, it's actually a exercise which I learned very early on in life, because one of the reasons I readily accepted becoming Solicitor General, although it was financially a huge sacrifice, was I wanted to see life on the other side of the fence. And when you work for the government, you realize their difficulties, you realize the pressures inherent in any government system. And then I did 1 or 2 cases for the UK government, US government in India. And I realized that you peel away a few layers and the bureaucracy is exactly the same everywhere. So, because there are certain problems inherent in government, democratic government, which sort of haunts everybody. And that is what you realize. So what I learned at that stage was recognizing the problems of government, accommodating them and dealing with them. So even now when you're appearing against a government, you know exactly where they are trying to cover up and where they have a genuine problem. So once you're aware of this, then it's not that difficult to accommodate these conflicting interests.
I think it in a way adds to your own skill, because if you are defending the other side, you already know.
Yeah.
Going back to bilateral investment treaties, India has signed a new treaty with Brazil, and there have been a lot of discussions about how it has departed even from the model BIT of 2015. In fact, they've completely done away with dispute resolution, the investor state dispute settlement mechanism, but now brought in something which is now called dispute prevention, which the state to state is allowed, but an investor can't bring in a claim against a state. Do you think this will become the new format for Indian treaties going forward?
The short answer is no, for the reason I know that the government has been trying to peddle this model. It tried to sell its earlier model, the model treaty, as the new avatar of BIT.
Yeah.
And I was consulted by some of the stakeholders, not the governments, but some industry organizations in the UK and in other places who wanted to sort of understand where all this was going. And I had a clear understanding from them that they were not happy. And they asked me what I thought was the problem. And I told them that without a dispute resolution clause with a country like India, a treaty is nothing more than platitude. The purpose of a bilateral investment treaty with countries like India, where governance is so difficult, the object of the treaty is to insulate international investors from the pressures which become inevitable in running countries like India. Now, if you have a treaty, and I know how the Indian, again, going back to your last question, I know how the Indian system works. So if something has to be done, and it's a difficult decision which will facially favor a private interest, no civil servant is willing to take that decision. So what does he want? He wants to be able to say, I tried my best, nothing worked. So I said no. The other side went to a court. The court decided, I tried my best, nothing works. So the decision making is shifted from the civil servant to a court or a tribunal. Now, if you don't have that mechanism, doing business with India, honestly, is very difficult. So if in India they make promises, there is nobody who will keep those promises. And secondly, on a matter of principle, if you believe in the goodwill of a country, you don't need a BIT. If you believe that a country will do well to encourage investments, a piece of paper saying, I promise you I will do my best to encourage an investment is nothing more than a piece of paper, unless there is somebody who can resolve a dispute. I believe when the UK treaty came up for discussions for renewal and the government of India came with the model, and the people who were consulting me, because some of them were on the UK side of the fence, and they said, look, what about dispute resolution? The Indian side, which was also headed by Sunil Mittal, who was Airtel, was the India part of the Indo-UK business. He said his instructions were, this is not negotiable. The government said, we will not have anybody questioning our sovereignty. Now, my point is a bilateral investment treaty is saying I will not use my sovereign power to hurt an investor. So if you say don't question my sovereignty, then you don't need a bilateral investment treaty. So this basic understanding has not gone into the civil service. And it is this fundamental mismatch, aspirational mismatch, which is underlying India trying to tell people to sign treaties. And the civil servant has told the government that, yeah, treaties are there, they're all under negotiation. I remember somebody who was there when the Prime Minister of India visited Canada, and he was talking about Canadian investments, and the Canadian Prime Minister brought up saying, yes, there are people who are willing to invest, but we're waiting for the treaty to be signed. And he said, I believe everything has been agreed. That was a wrong impression given. When he was asked about retrospective tax, he said, no, we fixed it. So this is the problem with India. The civil service has to accept that when it comes to foreign investments, there is somebody who might tell them that, sorry, what you're doing will not fly. And unless they accept that, then you might as well not sign a treaty. So my advice to everybody is, if you don't have a business treaty with India, then please build in the risk of doing business with India. Otherwise, best of luck.
So can we say, of course, for an investor, they look at different considerations when they have to invest in another country, ease of doing business, rule of law, etc. This becomes an important motivation, if there is a bilateral investment treaty for them to invest.
See, Shwetha, as I told, if you remember when the Vodafone thing was very current in India, and still at the time when the government was defending Vodafone. Now, of course, post 2014, they all became apologetic. And, Mr. Chidambaram in a discussion with Jetli virtually said, I knew it was wrong. I didn't have the political strength to repeal it. But at the time, initially, they were trying to say, oh, there's nothing wrong. And it was just a little mistake and we've corrected it, and black money and all that nonsense was being talked. At that time, GE had a similar problem. And they came to me and they said, what? I gave them my interpretation of the law in their favor. And they said, what if we win? I said, well, will they change it retrospectively? I said, who knows, they may. And you've seen this for those 2-3 years, there was a slew of retrospective changes every year. They said, how do we plan for this? I said, very simple. In India, one way is you take the tax, the highest rate is 34% or 40%. At 40% tax on gross revenues, is it worth doing business? If it is, then whatever you save in tax is a net saving, is your bonus. Now, if your leverage is that much, that even if on my gross income, 70% of the gross income gets taxed and I pay 40% tax on it, so I'm paying 28% tax. And even at 28%, I'm doing quite well. It's still cheaper than my next investment option, or still a higher return than my next investment option. Then you go for India and then you fight it out, knowing perfectly well, if you win, you win. If you win, it's an extra added bonus. If you lose, so be it. This adds usually to the cost of doing business in India. And that is the reason why India could have had, but has not had, that degree of foreign investment. You could have had a lot more. Today, what everybody is talking about is people revisiting excessive reliance on China. I hope India does well, but I have my misgivings about how much India will be able to capture of any business which is moving out of China for this reason. Our ecosystem is still very, very questionable on a lot of areas. And that is why in the ICI webinar, I said, the government has to now do something dramatic, like repeal the FEMA. You don't need it. If tomorrow the exchange currency starts crashing, bring in another law by ordinance. You can always do that. But repeal FEMA. Do something which tells the foreign investor that you are now willing to act with a sense of trust in those who are coming into India, not have suspicions about everybody who's investing into India. And the Prime Minister his Prime Minister's office and the Prime Minister have been working so hard. He has built India into a huge, the image of India has been built so beautifully all across the world. This is the time we can cash in. But on certain areas, in the fiscal side especially, India still has a dodgy reputation.
So just going back to what different governments across the world have done in response to the COVID-19 situation, there have been some unprecedented measures. And in fact, the level of state intervention into private rights is also quite unparalleled. Do you think this will find a way into bilateral investment treaty claims?
I don't know how far you'll be able to sustain a bilateral investment treaty claim, because on the anvil of reasonableness, I think most governments will be able to justify what they have done, at least up till now. And I don't think the governments have really exposed themselves to BIT investments, because fortunately, lockdowns, for example, and the kind of lockdowns which we have seen have been devastating, have been a global phenomena. So it's not a knee-jerk reaction of a country, or it's not a politically driven action, which, see, underlying all this, Shwetha, like in constitutional law, as in BIT law, if the arbitrators feel that what has happened is for what has been done by a government is driven by political considerations, is driven by knee-jerk, is changing avowed policy after investments are made, the arbitrators have a reaction where the arbitrators feel that a system in a country is what it is, and that's how it is, and there are problems which have to be dealt with. They deal with it accordingly. On paper, we had a very good case in the Indonesian arbitration, but we lost because at the end of the day, the arbitrators felt, well, when you go to a country like Indonesia, those are their problems. They have political problems. They have genuine governance political problems. So what was done was not really to target the investor. What was done was a reflection of what is the reality of that country. So today, now this is a global reality. This is not even a country reality. This is a global reality. The pandemic and the need to contain. And look at a country like India, where medical services are so sparse. If a country like UK had to bring lockdown because they were worried about the NHS being overwhelmed, and a country like US had to bring lockdown because they were worried about America, which has the highest per capita expenditure on healthcare, they were worried about their system being overwhelmed. Look at India. If COVID spreads in the rural areas of India, you won't even be able to count how many people are dead. Forget giving them healthcare. So I don't think these measures leave any real concerns. What is important is when the government comes back with a stimulus package, as I hope they do sooner than later. India is sort of lagging behind. India is not yet announced, and I'm sure they will. At that time, they shouldn't do anything which discriminates against foreign investors.
Yeah.
India, the biggest fear, my concern is the biggest fear at this time is countries will start turning insular. There is this feeling that you must bring manufacturing back into your own country, you must bring business back, otherwise you become dependent on the Chinas of the world, and then tomorrow when you need to do something, you can't do it. There was a very strong article I read in New York Times. And one of the points he made is, he says, look at this country which was manufacturing tanks in World War II, 8 tanks per hour. Couldn't manufacture PPE and had to import it from China. I mean, what's going on? Now, that kind of a thought process leads to insularity and leads to countries becoming islands, manufacturing islands. Now, that is if that's the direction things are going to take, then it becomes even more difficult. And if countries which have a BIT start taking measures which unduly favor domestic industry, you may then have BIT claims coming up.
Just going back to what is the current regime of investment arbitration in India? So India is, of course, not a signatory to ICSID Convention, and currently most of the bilateral investment treaty arbitrations are all ad hoc. Do you think, and everywhere we've been talking about how institutional arbitration is so important to give that efficiency, but how will we sort of fix this loophole in the Indian investment arbitration?
You never will. And let me tell you why. In India, we have a disconnect. Indian Arbitration Act and Indian Parliament is strongly pro arbitration. I think the Indian law was the first one to bring in the code of conduct into a statute. The IBA guidelines have been legislated in India, as you know. The Indian law has tried to, perhaps that was a bit of an overkill, fix time limits for arbitration. So on the one hand, India is very pro arbitration, and you've seen the 2 or 3 amendments which have come have always tried to remove courts from the arena of arbitration and make it pro arbitration. But the reality is, if you see on a macro basis, the single largest number of arbitrations are against the government. And I'm talking of ordinary commercial arbitrations against government departments, state government, union government. And they are the worst in arbitration parties. I'm doing 2 or 3 big international arbitrations against the Director General of Hydrocarbons. And my clients tell me that in private conversation, the members of the DGH say, yes, we want to stall this arbitration because we know otherwise the award will be in your favor. But then the Indian court will be in our favor. Now, that's the civil servants' mentality, that the Indian courts understand us. Foreign arbitrators don't understand us. In other words, they can sell their nonsense to Indian courts, but not when it is tested on a dispassionate level. Many times, even Indian courts reject what the bureaucrats want. So that may not be true, but they feel more comfortable because it's within their comfort zone to work with the Indian courts. Until this mindset continues, arbitration, especially BIT arbitration in India, can never be resolved. The civil service will, you've seen the model treaty, they don't want arbitration. So for them to agree to an institution which will put them to the rigor of a efficient arbitration is something completely unacceptable. You saw Vodafone took 6 years to kick off.
Yeah. Just before I move on to the questions, that the attendees sort of asked, just one last question, which is usually a very common question, but I think is extremely relevant. What are the general strategies you would advise to the young practitioners who want to position themselves as, for a strong career in international arbitration, whether as a counsel or as an arbitrator?
Well, you start as a counsel. So for youngsters to start arbitration practice, the starting point is you start working on arbitrations. There is a lot of scope to work at arbitrations. Don't disconnect yourself from courts completely because you will meet your clients when you're doing court work. But having said that, or if you're in a law firm, you focus on arbitration practice. Remember, your life will not be as exciting as your colleague who works in a court. But if you stay the course and if you work hard, arbitrations can perhaps at times be even more intellectually rewarding than court litigation. So that's my advice. Stay the course. It's hard in the initial stages, but then it's equally hard in litigation practice. So don't get deterred. And yes, you don't have the exciting cases which hit the headlines going before arbitrators. But if you're fond of the field of commercial law, arbitration is where it is increasingly happening all over the world.
Just going back to a question that we've received. So in the beginning, you had said that how it would be difficult to do cross-examination and of witness without zooming in personally and connecting with his energy. But how do you think we can overcome this problem? And we don't know how long the current situation is going to be. How will we be able to continue to function?
Well, I think we have not yet even fully understood the present problem. Every day, the scientists are coming up with different theories of what this illness is all about. I am an incorrigible optimist, and I know sooner than later we will find a solution to this problem. But to fix any dates today of when we will be back to the old normal is wrong. Secondly, the old normal must give way to the new normal. And I think if we have developed certain skills under compulsion, there is no harm in continuing to use those skills, adapting those skills and using those skills even in the future, if it leads to reduced costs. And yes, we all have to learn to be more flexible with our time. Even if I have to get up and do a hearing in the Indian Supreme Court, I have to be at my desk at 5 a.m. But so be it. It's much easier than flying all the way to India and living with jet lag. So, and so much more inexpensive for clients. So I think to provide service to clients, and clients all will be under financial stress after this lockdown. If we can make our services more efficient and less costly, more cost efficient, more work efficient, I think we'll be rendering a huge service to our clients and to society. So I think we need to learn these skills. I'm sure even cross-examining witnesses, creating virtual rooms. As we go along, we will write protocols of how this should be done. And once that is done, I'm sure we will be able to work it. It just needs the will.
Yeah. Someone's asked, how can more Indian senior counsel be persuaded to get involved in international arbitration as counsel and as arbitrators?
Well, that's a question which is very difficult to answer. It's only when Indian Supreme Court practice comes back. It is my firm belief, and I may be completely wrong on this, and I don't want to sound irreverent, but I think I've spent enough years in the corridors of that court to be able to say that. The model of the current Indian Supreme Court practice is unsustainable. The fees which my counterparts charged in Delhi are a fraction of what top silks charge here. This is an unsustainable model. The cost of legal services to commercial India has become astronomical. And even now, corporate India is becoming cost sensitive. Secondly, I see a huge change coming in India, in the business world. As you're seeing with the rigorous enforcement of the bankruptcy law, a lot of promoter-driven companies have gone under. The ones which have survived are the ones which have institutionalized themselves. Take India's biggest company, Reliance. What is going to happen to Reliance? Once Saudi Aramco invests, and once Facebook invests, and once GE Capital invests, and once Capital Partners invests, and so on, and Microsoft invests, and the Abu Dhabi Sovereign Fund invests, this will become an institutional company, because everybody will want the management then to be with an independent, powerful board and institutionalized working. Now, in an institutionalized working, I can no longer charge Reliance a fee which I want to, because Mukesh Ambani has great faith in me. I will have to compete with others to make my services competitive. Price, all right. They will say Mr. Salve is great, so we give him a premium, but not whatever he damn well wants. And this is going to happen to company after company after company. All companies are now going to need infusion of capital, and all this capital is going to come from private equity. And private equity will ask for efficiencies in working. And once efficiencies in working come in, one of the low-hanging fruits is cutting costs of litigation. So what the Indian model of fees is unsustainable. Once this corrects, then the leverage or the arbitrage of doing court work versus arbitration goes down. Then you will be able to persuade good Indian lawyers to take on more arbitration work and also to become arbitrators. Right now, the arbitrage is too much in favor of court work.
Next question is, oftentimes execution of foreign awards in India is difficult because of tracing assets becomes a Herculean task. What legislative changes can be brought to combat that problem?
Oh, we need a lot of First of all, recording of assets, ownership of assets, assets registries are unknown in India. Now, under the bankruptcy law, it's becoming good. The government has suddenly realized tracing of assets, especially even for Indian secured creditors, forget international arbitrators, is becoming a huge problem. So an asset registry law in which assets are transparently owned, transparently registered, and whose search is available online is the only solution. Now, the union government has taken steps to get asset registries in place. But I think we need a law with a independent regulatory mechanism so that companies and individuals and businesses can be forced to comply with asset registry laws and make false registration of ownerships a criminal offense. So I think, yes, we need that.
Okay, someone has asked a slightly sensitive question, saying, would Mr. Salve like to say a few words about some of the greatest losses in his legal career?
Some of the greatest losses. Yes. I'm an incorrigible optimist, so I forget my losses very easily.
Yeah.
But one thing I will say generally, it takes a lot to force me to read a judgment of a case which I have argued. I believe in moving on. And yes, there are some cases which we felt really bad about losing, where you felt you had a very good case and you felt the law was on your side. I had my first major loss when I was arguing before the Constitution Bench in 1981, the bearer bonds case. And I thought we had an excellent case. And I was forced to argue because Mr. Sorabji, who was leading me, got detained in Kashmir. And I remember arguing that case. The judges, especially Justice Bhagwati, who was on the bench, and Justice A.C. Gupta, they received me very warmly. They allowed me to argue fully. And then came the judgment upholding the law. And that, I was very depressed. And that is when Soli told me, he says, don't ever focus on a judgment. And one thing Mr. Palkhiwala taught me very early in the profession, when I told him about bearer bonds, he says, Harish, on a personal note, let me tell you, when you come out of a courtroom, you must ask yourself, could anyone have argued this better? And if the answer is yes, you need to work on your skills. If the answer is no, don't worry about the result. So I have followed that rule. So if you ask me which are my biggest losses, honestly, if you ask me about a case I've lost, I'm happy to talk about it. But I sort of delete it from my memory banks and move on.
Yeah. I think you've already, in a way, answered this question, but in case you've got something to add, this is on India terminating the BITs as response to a number of cases that it was seeing, and now they're trying to renegotiate the BITs. So this attendees asked that, will the countries be willing to renegotiate the treaties on the terms that India is expecting them to?
I don't think anybody has accepted the model treaty. I'm not talking of countries like, I don't mean to sound pejorative, but something like Belarus or something who agrees to sign a treaty with India because they need Indian money. But where India may not be willing to sign a treaty without dispute resolution. But what I have heard about the US, the UK, Canada, of the three major countries, have refused to sign the model treaty. And one of the main stumbling blocks was absence of dispute resolution. So, no, I don't think this is going to be a successful venture.
Another question is about that how India has done a lot in terms of policy to strengthen arbitration mechanism, but in terms of actual reality of government-related cases, we see that there is a big gap. And how is it that India, trying to position itself in international arbitration, can fill that gap?
If India wants to position itself in international arbitration, it has to be a joint effort, first of all, of the executive government and the courts. Indian courts, and especially Supreme Court of India, and it is becoming sensitive to this problem, has to make sure that the courts get off arbitration. We had the emergency hearing before a Singapore arbitrator. A suit was filed on the 11th hour saying that this dispute is not arbitrable. You had a judge on the original side who dismissed the suit, saying, go argue this before the arbitrator. He dismissed the suit. It went in appeal. And the division bench said, today we don't have time, we stay the arbitration hearing. Now, till this mindset continues, that, oh, why inconvenience somebody by going for an arbitration, we stay the hearing. Judges, till they continue to regard arbitration as something inferior to what they are doing, the problem is not going to get resolved. The other day I was settling an appeal against a judgment, a 200-page judgment, setting aside an insurance award. And the award says there are two ways of doing evaluation and discuss the merits and demerits, and substitutes method B for method A, which the arbitrators had followed. There is a Supreme Court judgment in which Supreme Court has interfered with the interest awarded by arbitrators. And a bench which normally is very pro-arbitration. Now, this kind of ad hocism in decision making, where Indian judges have got so used to doing justice by the seat of their pants, as it were, till this mindset goes. So it has to be a joint effort of the government and of the courts. And secondly, the courts have to stop encouraging the government's challenges to awards. In one arbitration, after delaying it for 3 years, after delaying it for 8 years, finally, when the arbitration was taken off, and we have a panel, a very eminent panel of Michael Kirby, Lord Ricks, and an Indian retired Chief Justice, and they allowed production of documents, the government carried it in appeal. The High Court dismissed it straight offhand, saying, how can a red fund schedule be challenged in the court, under which provision? The Supreme Court issued notice in the SLP, and the arbitration got delayed for 8 months. The court didn't find time to hear it. And when they heard it, they said, of course, the judgment is right, and dismissed it. Now, this kind of, government has come, government is being asked to produce documents by arbitrators, we must look at it. Now, this is a very anti-arbitration mindset. So the courts and the government both have to decide. Making laws is not good enough. There has to be change in mindset. And this mindset change is coming in small doses in the Supreme Court, but not sufficiently. And definitely not, I don't see it at all reflected in the working of the government departments, which are parties to arbitrations.
That is a very important question in Vodafone and Khitan judgments of the Delhi High Court. I think this is in relation to anti-arbitration injunctions that were filed by the government. There is a statement in the judgment which says that BIT awards cannot be enforced do not fall under Part 2 of the Arbitration Act. How do you think the BIT awards will get enforced in India?
You see, there is a gap. Let's be very clear. There is a gap. And globally, I've seen this problem. I don't know the answer to this question. One defense to an award is public policy. Now, if a bilateral treaty award says, take for example, Vodafone, fortunately, we don't have to recover anything. But suppose in the Kane arbitration, which is on the same Vodafone dispute, the government of India has recovered monies. If Kane gets an award saying pay them $500 million, and they bring it to an Indian court, and the government says, under law made by Parliament, we have recovered this money, any award saying pay back what is not payable under law is opposed to Indian public policy. What will the Indian court do? I don't have the answer to that question. So we have to create. So treaties apart, I mean, it's all very well. Most probably can go against Indian assets outside India and can get attachments and force, or ultimately it all depends on the goodwill of the government. So I think there is a problem here. And part two, enforcement of awards, if they are opposed to public policy. And the second problem is our part two is awards which are commercial in nature.
Yeah.
BIT award is not commercial. We have to widen part two and make a public policy exception.
I think there are a lot of questions, but I don't think 1 hour would be enough if we were to keep talking. There's just so much that one can learn from you. And unfortunately, we've run out of our time, but really thank you, for taking out the time. I think there is no bigger gift than the gift of time, and you've given that to us. And we look forward to seeing you at Axel Chambers soon. Yeah.
Sure.
Thank you. Thank you, Mr. Salve. Thank you.
Thank you.